worked with 501c status exemptions, negotiated large-scale collective bargaining agreements, employment and severance agreement. He's taught IP, commercialization, federal tax. He's done a lot of good things at Northeastern and Suffolk. So Bill comes with a lot of good experience, and he's very good at explaining it to you in simple layman terms too. So I will now introduce Bill and let you take it away.
Thanks, Gloria. I will try to share my screen here. Let me see, Gloria, I think you've got to stop sharing screen or
Didn't I do that?
I don't know. I'm sorry, folks. This technology, you notice, was not listed among the things that I know how to do. Let me try this again here. Obviously, we want to get up our slide presentation for you. Thank you for your patience. For some reason, oh, there it is. Okay. Okay, there we go. So thanks again for waiting. Let me start by saying, you know, my goal today is to try to help you think about things. Some of you, we've obviously been in this mess for a long time now, and hopefully some of you are seeing a little light at the end of the tunnel. But, you know, to add on to what Gloria said, we know how hard it's been for you if you own a small business, if you have a lease, if you're lost your customers or what have you. So please, don't hesitate to reach out to SCORE, even if you think it's a silly question or something. We're here to help. We're really keen to do what we can to help you not only get yourself back in shape, but plan for what everybody's calling the new normal. So please take advantage of those links and let us work for you to help you get back and help you and your family and serve your customers. So today, I'm imagining some of you are still dealing with issues with your commercial landlords. And so I wanted to just talk about a few things that you could do to try to reduce that cost that you're dealing with if you haven't successfully done so, or if you managed to get a little initial relief from your landlord, but still need some more. And the way I'd like to do that is to talk about some of the contractual terms that you may want to look for in your commercial lease agreement, because that's the document that's going to control your arrangement with your landlord. And then just to present to you, not that you're going to litigate, but some legal theories about why performance under a commercial lease might be excused at this time. And then I want to talk to you a little bit about how to put that presentation together to negotiate forgiveness or forbearance with the landlord or your lender in the case of equipment leases and so on, not so much bank lending, although these would apply to them too. Sadly, so I'll add that, you know, some of you may have to be thinking about bankruptcy just because the nature of the economy has changed and your particular business model can't be retooled to serve your customers or deliver your services under the new model. So, you know, I just want to talk briefly about bankruptcy. There is another workshop in the system. I think Dave Berman put that, but as Teresa said, there you can search through the workshops and see that if that's unfortunately something you need to think more about. And then to talk to you a little bit about what I think if you were to get to court or so on, what I think the world would look like. Just a little disclaimer that this is general legal principles. I'm not your lawyer, and unfortunately, SCORE people cannot serve as your lawyer. There are a lot of resources out there, and if you need information about places to go, you've got my email address. It was on the front page, and you can send me that, and I'll send you a list of places that might be able to provide some help. If negotiating contract terms directly, there are people that provide support in the bankruptcy context, talking to your suppliers about improve terms and so on. So again, reach out to help, let us help you. And if we can't, to connect you with professionals, hopefully that are no fee or low fee who can help you. Let's see here. So that's pretty much what I've said there. Again, I want to be able to help you. And as Gloria said, we all are here to help. So let's kind of jump into it. The four words I want you to think about here in terms of your obligations to your landlord or your commercial lender are reduce, renegotiate, delay, or forgive, depending on your situation. And I'm just going to tell you, because I've helped quite a few people through this, so it's not data, but it's an anecdote or a series of anecdotes, is that people can successfully reduce those terms. Landlords understand, and I think better understand now than they did in the beginning of the pandemic back in the earlier part of the year, that they're going to have to make some concessions, and that the last thing they want is a bunch of defaulted leases and debt obligations that they're going to have a really hard time collecting on. So they're going to be more flexible, I think. I just read or heard an interview with one of the largest Section 8. It's a residential housing, but they are working to reduce everybody's burden. They're the biggest residential landlord in the state. And they finally realized they needed to do something here. So they're working very hard not to have people default on them. And I suspect that you're seeing the same thing on the commercial side too. So what might be available to you? Just starting off again, I should have updated this slide. It's the COVID-19 ScoreVolunteer.org website will now kick you to the regular website. But again, we're still here to provide help to the extent there are lending vehicles available through the SBA and the federal government. We have people that can help you with that. If you look at the next link, the American Bankers Association, they've taken some proactive steps to let you know what specific banks are doing, which may include your bank. So if you've got an equipment loan or something through a bank, it would be good to check. Even if you've got just a business line of credit or something, check out there and see what they're doing to help you. You probably are familiar, but if you're not, you should be looking at the loan deferral and forgiveness programs of the SBA. The Mass AG has a program. If you're in Boston, there's a small business program. There's a Mass Small Business Grants, and there may be, depending on where you are, I think Springfield and Worcester also have some programs dedicated for businesses in their areas. So, you know, to the extent you need loans that aren't available through the PPP or support through that, you can be aggressive and reach out to your particular lenders, reach out to these municipalities that may have funding available, and just see what's out there during this time, because there's more little pots of money than you might think. Here's a little bit of good news if you're in a commercial lease, which is, at least for now, and this is now through August, so we're getting up to it, but it won't surprise me if it's extended. Governor Baker signed an emergency order saying that courts are not to pursue or permit commercial evictions except in very serious circumstances. So if you're a small business and you're in a commercial lease and you're behind, your landlord is not going to be able to pursue an eviction except in certain very rare situations. So that gives you a little leverage. It gives you a little time to, again, work if you haven't been able to work with your landlord. In this case, it obviously doesn't apply to commercial lenders, but you know, and it gives you a little leverage. And even if you've already been there once, if your situation hasn't improved, some of the things we're going to talk about today will give you a chance to go back and maybe revisit whatever concessions you received from your landlord the first time. This is less likely, but for some of you, you may check in terms of resources to see if you have insurance coverage. Some people have what's called business continuity insurance that may cover interruptions like this. Some people may have key person or key man insurance. If you or someone that's high in the organization became ill because of COVID and was unable to perform your duties, there may be insurance support available to you there. Again, it's not highly likely, but you should, again, we're at the point where we're exploring every option. So just make sure you've reached out, if you haven't, to whoever's writing, your agent or your broker, or if you're online directly to the insurer, and just see if they have anything that would respond to the business continuity, business interruption, or illness of a key executive. So now we're going to take a look at some of the terms in commercial leases and lending documents that may give you some relief. And these are not, evenly, fairly written documents. They're usually written largely in favor of the landlord or the lender. They're hard to read. And their main goal is to shift onto you as the tenant or the borrower the risk of loss and so on. And so when we discuss kind of negotiating strategies, what we need to remember is, despite those documents that seem to put everything on you, they have a risk too that they didn't have before, because when the economy was strong and everything looked good, going into court to collect from you was something they did routinely. But my sense is that when the courts do open back up on the commercial real estate, and certainly on debt collection, they're going to be flooded. There's going to be a lot of defaults. And my sense, and the sense of a lot of people that I've read that work in this space, feel that judges are not going to be quite as even-handed or lenient as they might be towards the landlord or the commercial lender. And they're going to take into account some of these issues. So the reason I raise that is because I think it changes the calculation for the lender about what's their best path. In the past, they would say, well, I'm just going to sue you and, I'll make your life miserable. But that's not going to be the relief it used to be. So we'll talk about that a little more. But I just think when you're thinking about your negotiation, you want to think about your leverage, your negotiating position, and I want you to feel a little more empowered than you might. And when we talk about some concrete steps, I'm hoping that'll help you feel more, so that you can put a presentation to your landlord or your lender and have hopefully a better outcome and get more of the relief that you need. So looking at specific clauses in a contract, one that you need to make sure of, and they're typically in there in some form in a commercial lease or a lending document, that's called a force majeure clause. It's a French term that means the major force, and it means something that's happened that has overcome the ability of one or both of the parties to perform under the contract. Sometimes they're very general, sometimes they're one-sided. I've seen some that say only the landlord is excused from performance, but a lot of them are more even-handed, and you should know what language is in there. And you specifically want to be looking for words like epidemic, pandemic, shut down by government authority, or a general phrase that lists a bunch of things that might happen and then has a catch-all phrase like including but not limited to. And if you have that phrase, that's the broader that is. And again, you've got my email, so if you want me to look at your force majeure clause, if you find it, feel free to send that to me, and I'll be happy to tell you what sort of leverage or rights you have there. But that's the first place you want to look, because we've had government shutdown, we have an epidemic and a pandemic, and certainly this is the kind of thing that neither party anticipated when they signed the lease or the commercial lending agreement. You both thought you were going to be able to use the equipment to do your job and make your payments, or use the space to have your store and make your sales or whatever. And the landlord expected that, and so did you. So the thinking there is that neither party should suffer because of something that's outside of both parties' control. Again, so the broader those terms, the more specific, if they mention pandemic, the better. And again, I encourage you to feel free to share those with me if you care to. Now, sometimes your lease will have terms about what the landlord is required to do in order to keep the premises clean and safe. So you want to look in your lease to see what the obligations are of the landlord with regard to the common areas. For example, if people come through a lobby or something into your space, if you have an HVAC system that's shared by the whole building and the air from the lobby can be getting in there and maybe they're not taking the precautions they need, you want to make sure that bathrooms, lobbies, elevators are being appropriately sanitized according to CDC standards or the mass standards. And both of those are online in terms of what Massachusetts expects, and the CDC recommendations are there as well. So if your landlord isn't keeping your premises as clean as you think it needs to be safe for your potential customers and yourselves, then this is an opportunity to step in and say, look, you need to get this place cleaned up and I'm not coming back in. And typically you'll have a right to suspend rent payments until the place is brought to a proper level of sanitation. That's, again, not necessarily in your lease space, but in the common areas and so on. So look to your lease and see what's there. The clause is typically called landlord obligations or something like that. Another term that you want to look for is called quiet enjoyment. And this talks about the right that you have to be able to use your space as anticipated under the lease. So it's a little broader and a little harder to deal with. But again, take a look at those terms, see what's there. If you don't see it so much with the really large commercial landlords, but some smaller ones that I've heard are not particularly doing a good job of keeping their spaces clean for their tenants. Maybe they don't have the money, maybe they can't get the service. So if they don't have that and they're not doing what needs to be done, you should feel free to see what your rights are if the landlord doesn't fulfill their obligations. And if you're entitled to either stop rent or put them on notice that you're going to take your own steps to keep the place clean and offset rent by that amount or what have you.
Hey, Bill, I hate to interrupt.
Nope.
I had a participant say that they can't see the right-hand side of your screen because you're running, it's just in PowerPoint and the slideshow isn't actually running. Could you run the slideshow so they can see the full slide?
Of course, yeah, I'm sorry.
No, not.
Let me see if I can do that, but I'll try to.
From current slide, yeah.
Yeah, how's that?
All right,
Let's
I will let you know if I get any reply. Thank you.
All right, yes, thank you for catching that. Let me back up here. Okay, so, all right, so we were just talking about landlord's obligations. Now, the other piece that I want to tell you about, because a lot of you may have a business and you may have an LLC or an S Corp or maybe unlikely a C Corp, but even if you have the lease in the name of the business, you're often, for a small business, have a personal guarantee attached to this as well. And so you need to understand that if you have that personal guarantee, you're obviously personally liable for the obligations under the lease. So you need to understand if you have one of those, because that is not something that works in your favor, and it brings into play all of your personal assets that you may own, except, and this is a big except, if you own a home and you have a personal guarantee, Massachusetts has a homestead exemption, which protects $125,000 of equity in your house from creditors, which the commercial landlord would be, and that's statutory and that's automatic. If you file, you get up to $500,000 in home equity. I've given you the link there about how to do that. It's a very simple thing to do. I don't think it costs more than a couple of bucks. And if you do have a property that has higher equity, this is a nice way to protect that from creditors in the event your personal assets at risk as a function of as a personal guarantee. Are there any questions at this point before I move forward?
Yes, Bill, we do have one. A Regis customer has not had success talking to the office managers about terminating the lease. How do you get effectively to bring this up the ladder to the corporate management when he has no contact?
When the regional manager, the office manager has no contact, or
No,
the tenant has no tenant?
The person leasing the lease can't find anybody to contact at the management company to negotiate the lease. They just can't get through. You know how people don't know phone numbers, no names, no nothing.
Right.
And so I think he's having trouble even finding the right person to talk to.
Yeah, so we're going to start to talk about that a little, but I think one thing to do is probably to get off the phone and get off the email and start writing something a little more formal that says, look, if you're not in a position to respond to this, you need to forward this to somebody who can. I'm putting you on notice that I'm going to take the following actions unless I hear from you. So we can talk about that, but I think that first line person, if I'm understanding the question correctly, at Regis is just there to deflect. They're hoping you'll wear out before they wear out. So what we're going to talk about here is a little more formal approach where you're not going to get on the phone and talk to somebody. You're going to put together a formal presentation that's going to include some data, and it's going to include some data that you're going to want to do to test for yourself the viability of your business going forward. So does that feel responsive?
Yes, thank you. There's one more here too.
Yeah.
I just paid my property tax bill for the second quarter 2 weeks ago.
Mhm.
Brookline is now insisting, despite calls and emails, that the next payment is due in 2 weeks. I've written off months of rent payments to keep them in business. I'm frustrated and broke.
So they may have to expand on that question. You paid a quarterly bill and now the next quarterly bill is already due, is that right?
I paid my property tax bill for the second quarter
Right.
2 weeks ago, and now the next payment is due in 2 weeks.
Well, so
it sounds like they may be having, I don't know, do you want to write a little bit more, Jerry, on that? To clarify, my tenant has been unable to pay.
right. Well, the landlord is obligated to pay the property tax, and collecting from the tenant is obviously a different issue. It's a legitimate claim against them. Have you asked the town for an abatement or a deferral? Sometimes you can agree to defer that payment for a period of time, or maybe pay a little interest on it. And typically, if you're the landlord, your lease will say, we'll have a late payment provision if they don't make their payments to you when they're obligated to make them. Again, my focus here, Jerry, is on the tenants, not so much the landlords, but I think you're in the position to say, to ask for some relief or abatement from them, understanding that you don't have any cash flow coming in.
Okay, thank you. That's it for now.
Okay. So again, I'm going to say two things. One is, this is not a time to be shy. I'll say three, I'm going to add one, or I guess it's in the second part. But it's also not a time to be unrealistic. And part of what my message to you in the next couple of slides is as you're thinking about your presentation to your creditor, whether it's a lender or the landlord, you need to be thinking about that same communication to yourself. And do I have a business that I can make a credible case to my landlord or my lender that I'm going to come out of this and be able to make good on the obligations that I have, or do I not? And that's a hard thing to say. And I know small business people are very optimistic and they work hard. So, but part of what I'm going to encourage you to do, and this is where SCORE can be helpful. And, you know, Gloria, who's here with us, is one of those people that has real deep skills in kind of pricing and evaluating your numbers and so on, is to really be realistic about where you are and what your prospects are. In terms of the model that you have with the equipment that you have or the commercial space. Like if you need to pivot to an online business and you just don't see a model for that space, it's better to understand that up front and let the landlord know where you are than tell them you're going to try to go forward and then come back later saying, well, I was wrong. So let's push that thinking now. And it's time to be professional. And by that, back to what I was trying to say to the earlier question, is it's time to start putting a business-like presentation in writing that's thoughtful, that's thorough, that's respectful, but tenacious of your position. And finally, understanding what your alternatives and their alternatives are if you can't reach an accommodation or a negotiated agreement. So again, SCORE can help you with these. But you really, it's going to take a little homework. I'm sure you've all been doing your homework about the future. So you've probably done a lot of it. So number one is assess your prospects. It's important for you to really rationally assess them given where they are. I mean, all the data that I read, unfortunately, and the opinions is that we're going to see just a flood of failed businesses when these sustaining programs disappear, which they will do at some point, and business models have changed, and shopping and consuming models have changed, and even service models have changed. So be realistic about where you are. That's important for you. And then it's also important for you when you present what we're going to talk about to your landlord, and also be realistic about where they are. You know, we heard from a landlord a minute ago. I mean, he didn't plan on not having tenants be able to pay their bills, and he still has bills to pay in terms of maybe his own debt service and so on. So I read something the other day that said, we're not all in the same boat, but we're all in the same storm. So let's work together. And I think that's kind of a good way to think about it. So we don't have the same problems as the landlords and creditors, but we have an overlapping set of problems that we can treat as a business problem and solve that way. So again, bankruptcies are going to be skyrocketing. Defaulted payments for uncollectible debts are going to skyrocket. People are just not going to, you know, the recalibration hasn't taken place yet. So the more you can think about, and if SCORE can help you think about where you're going to be, the better. Again, you and your creditor have mutual interests in that the best scenario for them in most cases, particularly the commercial lender or the commercial landlord, is to have a viable tenant in that building. Even if in the short term they're not viable, if you've been a long-term tenant, if you can present a plan that we'll talk about to show that you will continue to be once this is passed and we've recalibrated, that's good news to a landlord because they think in the long term, you know, that's their business model for the most part. So let's think about that and how you can either buy time, and as I said before, either excuse payments, if they're past due, defer payments, reduce your obligation. If you think you've got a future in a brick and mortar environment, maybe renegotiate for a longer term with shorter payments up front and longer payments when you're back or more higher payments when you're back on your feet. I'm recommending this book to you because it's a great book just in general for negotiating. It's very short, it's very simple. You can get the original version for $1 or $2 online. It may be available free, but it's a great way for you in any of your business negotiations, but particularly in this, to think about how to negotiate and how to frame what we're going to talk about here to your lender or to your landlord. So number one, to maximize your position, and this is really the meat of it, is, again, do your homework, be able to write down and explain to the lender or the landlord your situation, your predictions, your current situation. You don't have to tell them every detail, but some numbers would be useful, and why, link what your situation is to what your ask is. So if you're saying, we were shut down, but we're starting to open back up, we're seeing customers flow in, but I've got 12 months of, or 9 months of unpaid rent or partially paid rent, how can we restructure that? That's one scenario. If you reach the conclusion that you're unfortunately out of the brick and mortar business, how do you get out of the remaining obligations under that lease? By showing them what your capacity to pay is. It's a step you would go through if you were sued. It's a step you would go through if you went into bankruptcy. There's no reason not to take a shot at having that conversation with your creditor, either certainly with a commercial lender and certainly with one that's nearby. I think Regis probably is different, but I'm still going to recommend that you go through this exercise and, again, tell them that you need to be in touch with someone who can respond to this question. And just keep putting that on him, and just him or her, and push it from there. So we're going to keep it businesslike and objective. And I can tell you this has worked, because I've talked to 4, again, it's not data, but it's anecdotes, 4 people who had situations that were difficult. We went through this process together, and they've all gotten relief from their landlord, more than they had been originally offered. So, I think it works because it's not a conversation. It gives the landlord, it shows you're being serious, it shows you're doing your homework, and it gives them a rationale to maybe do things that they wouldn't ordinarily do. So know what you're asking for. Are you asking for restructuring of the terms? Again, I can't pay $2,000 a month now, but I can pay $1,000. And maybe we can extend the term. And when I see my business back on my feet, because I've done my analysis and I see the business coming back, I'll be able to make that increased payment down the road. In terms of commercial equipment leases and so on, or bank loans, can you lower the interest rate? Can you change the payback period to lower the payment by extending the term? Again, lower the payback term. Can you get a payment reduction or rent vacation, as they call it, for a period of time, even if your prospects suggest you can do it, to add that time to the end of the lease? But this is why doing that analysis of your business to convince yourself and to convince your lender is so important. Because if you make a credible case that you'll still be around, it makes more sense to them to think about showing some flexibility there. If you're not going to be able, if you've got a little cash on hand that you've set aside, you might be able to look at a reduced rate buyout. The bank takes a haircut a little bit and you pay out, but then you're out for under the lease, because the uncertainties of collection have gone up dramatically for people. So you can always ask for a buyout. It's not uncommon, certainly when people get into collections, and I've done a fair amount of work in another scenario for people who are in bad debt. If you've ever been there, you know that when the car loan credit company, when that gets to the third tier collection agent, they'll settle those for pennies on the dollar. So you can, if that's an option for you, you can have that conversation for a loan, or you can have that conversation in your lease if you have to get out of it, to say, look, it's not going to work. Let's find a number now that we'll both, as I say, take a little haircut, but you're not going to have to collect, and you don't have any uncertainty of trying to have me go into bankruptcy or do whatever I need to do to protect myself. So again, the dynamics have changed. Let's use that leverage to our advantage after we've done our homework. So
Bill, I have a question.
Shoot.
Will you be talking about a blind trust at all? Someone says here that they've been told that their property is owned by a blind trust and there's no negotiating with such an entity.
That's not true. I don't think. The trust obviously entered into a negotiation when they signed the lease, right? So I don't think that's a true statement. I think what you've got is a lot of people that want to come up with ways to brush you off, right? But obviously the trust has, somebody has to sign and administer the lease. So that person is a fiduciary to the trust, who is in the position to make decisions about what's in the best interest of the trust. Like, the trust didn't decide what the lease term or what the rent was going to be. The trustee did that, right? So I just would not take that at all as a true statement.
Okay, thank you, Bill. Appreciate it.
Okay. So again, to Gloria's question, whoever asked it, keep pushing, be respectful, don't take no, ask when somebody says that's the case. Now let's take the blind trust, say, well, how can that be? Who set the rent for the place? Explain to me more how you can't negotiate a lease when I negotiated a lease. I negotiated the rent and everything else. So all we're talking about is negotiating the lease terms. And ask a question in response to a no, rather than just say, and it can be why, or could you explain a little more about how that is? And then again, how could it be that my lease terms were subject to negotiation if a blind trust can't negotiate? And that's what getting to yes, that book I referenced will help you think about too, because it's about how to collect the facts that lead to a conclusion or a position. So again, even a blind trust shares in the risk. And if you have to default on that lease, whoever is the fiduciary is going to have to try to collect it. Or when you get down the road, they're going to, again, negotiate with you about whatever term they can get. So, and remember this, I think people on both sides forget this, but I think sometimes landlords forget this too, which is just because you're a landlord or a lender doesn't mean you're guaranteed to make money. You take a risk every time you bring in a tenant, every time you lend money for an equipment lease or a bank loan or whatever. The question is how much? So the risk dynamic has changed in that because of the likelihood of defaults from people who have been affected by COVID and the pandemic, their risk has gone up too, which means their flexibility about different solutions to this problem should be greater, not less. So if there's no questions there, again, we can, if you have them, we can talk about more, and I'm happy to talk to people about specific presentations you might make. Again, the SCORE team is here to help you think about how you put your numbers together to show them and so on. It would not be my expertise, but use that, do your own homework, and let us help you communicate. So the next two things I want to talk about kind of go back, but they're just a way to help you understand a little more about how the law thinks about things like the pandemic affecting the obligations under contract. And they kind of make common sense. So you're not going to necessarily raise these in your communications. You don't want to be talking to anybody's lawyer. You want to be talking with decision makers, but they're good terms to understand. So the first one is impossibility of performance. And this is a long-standing term where, again, when people buy into a lease, just to pick that as example, one party can't do what they hope to do under the lease or what they agreed to do because of some event outside of their control. It's kind of a common law version of the force majeure, which would be a clause written in the contract. So the assumption when you sign a lease to have a nail salon is that you're going to have customers who come in to get their nails done, and they're going to pay you and you're going to pay the landlord. So when the government shuts down brick and mortar stores for 6 or 7 months, and then says you can only have half your, I talked to a barber the other day who says his business is half what it used to be because instead of serving a customer every half an hour, it now takes them an hour. They have the customer for half an hour and then they have to clean for a half an hour. So their business base is cut in half. So that kind of stuff is a common kind of term. And I think just saying that this pandemic has made it impossible for us to generate the income that we hope to receive in order to pay our obligations, including our rent to you, is a perfectly legitimate and sensible, common sense way to think about that. So again, I think it's typically been limited, but to the earlier point I was making, I think when these things start showing up in the courts, you're going to see some flexibility on the part of the judges to entertain these terms. And I think you're going to see a lot more, and this isn't just me, these are other people that are smarter than me about it, who think about litigation and representing landlords and tenants and so on. You're going to see the courts putting a lot more pressure for people to settle these things. And the settlements, I think the courts are going to say, look, I expect you to get out of here and come back with a rational resolution to this because we're not going to litigate this. And if we do, I'm going to think differently about terms like impossibility of performance than maybe I would have 2 years ago when the economy was stronger. And the same thing is for this one. Again, if you don't have the force majeure clause, this other clause is similar to impossibility performance, but it's called frustration of purpose. And again, you got into that space because you wanted to run your barbershop or your retail outlet or whatever, and you can't do it. So again, this is a term in the law that would excuse performance under a contract. So again, you're not going to, using the term isn't the point, but understanding that there's a legal strand of thinking that recognizes the fact that when the parties enter an agreement, they make certain assumptions that aren't necessarily in the lease. But one assumption would be, I'm leasing you this space so that you can run a retail establishment, and maybe it goes into more detail than that. But if that assumption proved not to be true because of the shutdown, then that changes your leverage. It changes the risk that the landlord particularly has a more slam dunk case to win should you go to court. And again, they're business people and there are costs associated with collecting and everything else. So what we're trying to do just generally is think more about that risk dynamic and the pros and cons that each party has of finding a rational settlement based on the facts as you can present them, to the landlord, as opposed to deferring this down the road to some third party situation where the decision about what the landlord or the creditor is going to get may be in the hands of a third party, like a judge or an arbitrator. So I think I've kind of beat that to death, other than to say again, I just think the courts are going to respond to this wave of litigation with more flexibility than they did when times were good. So again, this is, I hope, a situation none of you are facing, but you should know what's out there. I see this event has passed. I'm sorry, but as Teresa, I think, said, this webinar would be available online for you too. Dave is an expert in this field, and I wasn't able to attend that one, but I've worked with him a lot, and I'm sure it's excellent. If you're filing, I can't talk a lot here today about bankruptcy, but I wanted to list for you some of the resources that are available to let you know, first, that the rules around Chapter 11 filing, which is kind of a reorganization to reduce or excuse debt obligations for your business, might be, they have been relaxed, which is good for the small business, to get out of it, to restructure your debt and come out on the other side if you can make a credible case that you can. The link there from Investopedia is just a good overview of how to go through Chapter 11, and Fortune 500 article the same. The bankruptcy court website is a great source of information about the processes, about how you can go through bankruptcy. Again, hopefully you don't have to, but if you need to, pro bono. And maybe just as importantly, there's a list of nonprofit counseling centers that will talk to you. Some of them charge a fee, some of them don't, to assess whether bankruptcy makes sense for you. And again, they're going to ask you a lot of the same questions that you're going to answer when you're doing your own self-assessment about the viability of your business and when you put your presentation together for your landlord. So, you know, it's the ugly side, but if you're not sure that you're going to move forward, it would be wise to be thinking about this now and get a better sense of where you might be, if only in part so that you understand what you might need to insert in the conversation with your creditor about what your options to a favorable negotiation would be. That if you can't get terms that you like, you may have to seek bankruptcy protection. So that's the presentation. I don't know if you have any questions. I'm happy to stay as long as you find it useful. I hope you found this part useful. Again, there's a lot of SCORE assets in Worcester, Springfield. We've got a national access to everybody in the country in SCORE. There's a lot of legal services out there. So my daughter was in a school years ago, and their motto in part was, "Don't worry alone." So don't worry alone if we can help you or somebody else can. And I'll stop there. Anything else, Gloria?
Sorry. Yeah, I guess I'm going to read a couple of these for you. Okay. I'm a tenant and I have the same issue. First quarter 2021 property taxes due 8/1. Does the eviction moratorium form by time if submitted for the month of August, since the property tax is part of the rent?
Well, do you owe the property tax to the landlord or to the taxing municipality?
I'm assuming it's the tax municipality.
Okay, so if it's the municipality, you should write to them and say, I need some time to pay this. And here's why I'm behind. We're shut down. A lot of times they may want to put you on a payment plan, but I think you should start by saying, can I have, and again, this is where that presentation, you need to know, but if you can say, I've run my numbers and I expect to be able to make this payment by 60 days out. That's a better ask than to say just blankly, can I have 60 days? So if you are in the town and if you happen to live in the town that you are also being taxed in, you might reach out to see if your Board of Selectmen or whoever represents you has some guidance for you about what you should do or whether they can intervene to get you some relief there as well. So use those local politics. But in terms of your presentation, either to the landlord or the taxing authority, I think you want to be able to give them some numbers to explain to them the basis for your request for a deferral, an interest-free deferral, I would start with.
I have sent information to my landlord about how landlords are now eligible for an EIDL money, and I've asked them to take advantage of that option, knowing that I'm not able to pay the rent going forward. There's language that specifically instructs landlords to estimate unpaid going forward. I have heard nothing from them. You say just keep asking, just keep sending emails. How to get them to respond?
Well, I guess my response there is you're asking them to do something where they're going to make a business decision about whether it's in their best interest or not. So what they want to whether they want to borrow that money, whether they want to open their books up in a way to do that, that's entirely up to them. I would suggest that you think about telling them along the lines of what we discussed earlier, and hopefully that was clear, why you need relief or why you need excuse for your inability to pay based on your presentation of the facts as they relate to you. What you're telling them, as I understand it, is what they should do to solve your problem. And they may not see, they may have their own reasons to seek or not seek those loans, but even if they got that loan, that might not necessarily solve your problem. So I think you should more directly address this from your perspective and do your homework and explain to them why you need what you're asking for.
Bill, there's a question here. I'd like suggestions on how to try to negotiate with Verizon. I have a business account that I would like to convert to a residential account. They say there is a $2,000 penalty fee.
Right. So again, the message is to say, I don't have $2,000. So I guarantee you somebody can reduce that number. And all these companies do is hope that you will give in or so on. So I think a little more of a presentation. Verizon is tougher. I'm not going to tell you they're not, but they also have a lot more flexibility. So they're already and will continue. Remember, every time they get a bad debt, that's a tax write-off for them. And they're going to sell that paper for pennies on the dollar anyway. So what you need to just say is, look, I've looked at my numbers, and unfortunately with Verizon, you might want to lowball them a little bit, but to say, I can either not pay and, good luck to you down the road, but I'd like to, treat this as a business decision where, bad things happen to both of us. And I've looked and I've scratched, and here's what I can pay to get out from under that. And they'll come, unless you've already done that, I suspect they will come back to you with a number that's lower than 2,000. And, if you left yourself a little wiggle room, you can say, I'll see if I can find a few more dollars. But it makes no sense for them, if you think about it, to have a $2,000 debt from you that they can't collect, because they're never going to recoup $2,000 if they have to go to collections. They'll sell the debt for some fraction. They'll go on, and the debt collection company will try to get as much from you as possible, and then they'll settle it for something slightly higher than the fraction that they paid for it.
There's another question that came through chat. I was evicted on Wednesday. I'm looking for commercial property for leasing due to being evicted. I need commercial property to operate my business. Any suggestion for looking for commercial property and how to negotiate?
Yeah, well, first I would start by asking myself, I'll take you at your word that you need it, but I would push really hard to see that I actually need it. And if I do need it, do I need the amount that I think that I need? And then do I have the cash flow in order to enter into a new lease? So I guess you must have been considered an essential business of some sort for the landlord to be able to evict you, or maybe it wasn't in Mass, but if it was in Massachusetts, I would have thought the moratorium would have protected you. But what you're going to have to be able to tell a landlord is, and tell yourself is, you've got the assets and that your business model warrants entering into a new obligation. That being said, what you might say, because there's a lot of space that's going empty, is you might approach somebody that has what we would think of as a distressed property, where you would say, look, I'm wondering if you have anybody who's a tenant who's underwater, who's not paying you, who maybe I could look to pick up that lease for a shorter term, but make things easier for you and get them out from under the lease. So I would bottom fish a little bit there, because there are a lot of spaces that, even though they're technically still under lease, are not, the lease obligations aren't being met. So that's what I would do. In part, I would be aggressive in negotiating my lease terms and the length of the lease. And I would say, you know what, why don't we start with a year's lease, or 6 months or a year, and then have an option to renew based on that. And so you're going to limit your exposure by limiting the term. See if you can find something that's distressed, where the landlord can work with an existing tenant and with you to get somebody paying in there, and obviously get as aggressive a set of rent and related terms as possible.
It says our lease is up next March, and we are a restaurant. We haven't paid rent since closed. Open takeout only till the end of August because the summer is very slow in our area. Our rent increased 5% a year, or our rent increases 5% a year. What's the best way to renegotiate to stop the increase in our new lease term? Don't think we could pay rent the rest of the year, but we could add with the new lease for the next couple of years. The office manager is not helping, but planning to reach out to the main office.
Okay, so this is where you want your number presentation to come in. You've got two issues really, right? Which is, you've got your in arrears currently. So you've got, I couldn't tell whether you were paying some rent or were paying no rent, but either way, I would make the presentation based on what you're behind on, what you can do to satisfy that after you've done your numbers and you know what you're going to be capable of doing, and you've determined that your business is going to be viable at some point in the future. Then I would say, for the rest of the lease term, here's what we think we can do. We project when summer's over and the fall comes and people come back to our area, maybe we'll have more revenue, so we can do a little something there. In terms of the new lease, the first question I would ask is, when do you have an option to get out of the lease by a certain date? Like if you give them 60 days non-renewal notice, just keep that number in mind. Not that you want to exercise it yet, but typically there's a term like that in there. And then you would say, well, based on our projections for 2021 and 2022, this is what we're going to be able to do. That's an informative number for you, and it's an informative number for the landlord, because if you can't make the lease payment as envisioned by the renewal in March, you ought to know that for your own business. But you also, your best opportunity is to tell the landlord, I can't do that, but I can do this. Can we work something out that might include a longer term or shorter, lower payments up front for the first year, and then maybe looking for a higher bump. So maybe it's flat in year one, in March to March 2022, but then it goes up 6% in March 2023. You see what I'm saying?
Okay. What is a reasonable percentage of for a sales rent model? I have heard 5 to 6% for a clothing boutique. Landlord wants much more and renew for 2 years.
I don't know that. I wonder if we have people that know a lot more about commercial leasing, and I don't want to put Gloria on the spot, but she's a very wise head in this area, so she may know more than me.
And unfortunately, I don't either.
If you'll send that question to us, we'll see what we can find, okay?
Okay, right now I am month to month after the commercial lease expired, have been paying rent in this arrangement for 10 years. I'm wondering if an attempt to renegotiate will have them wanting me to sign a lease. If so, is this a good idea? What I really want is to stay month to month, but reduce rate for the time being. How likely do you think this is? Also, our management company hasn't been responding to requests to talk, so we have to find a way to reach the owner. Any suggestions?
Well, if you've been month to month for a long time, I would start by saying, look, I'm happy with the month to month arrangement. Although you should ask yourself if you'd be comfortable with maybe a year's lease, if your business model and your calculations support that. But I would open the door by saying, look, again, we've run our numbers. This is what we're going to be able to sustain in terms of rent going forward. We love the month-to-month model, and we're happy to stay on that, but we need to negotiate this term at least for the next year. And we can talk about, and again, try to be creative by playing with the term. The length of the deal, month-to-month, is tough. And remember, on a month-to-month, you're at risk too, because they can just tell you at the end of a given month, that's not an eviction if your lease expires. So, they're not evicting you for non-payment at that point. You just don't have a lease anymore. So there is some protection in having a lease, but I would present to them, after doing my homework, a brief presentation of what you think your business will sustain in terms of rent, at least for the short term. In terms of who you can find other than the office manager, the lease is owned by somebody. So, the building is owned by somebody. So in the registry of deeds, there will be a trust or an LLC or something that owns the property. And in the Mass Secretary of the Commonwealth, if it's a corporation or an LLC, you can look and see who the members of that LLC are. I'll just say an LLC, but any business entity, if it isn't on the deed that shows the property, the owner will be in the Mass Secretary of Commonwealth, and that will list not only the members of the entity, but at least a business address for them. But again, one step, let me just finish with this, is to say, always send something to the office manager saying, this is a formal request to do the following things, and we will pursue this with the owners if we're not able to reach agreement through you.
Okay, before I ask the next question, I'm going to go ahead and launch the poll. We just have 2 quick questions if people will answer those, and then I'll read the next question.
Okay.
So there's the first poll. So we have someone that said tenant must to notify the landlord that will pay the partial payment of rent. And what happens if the landlord did not respond and receive the partial payment of rent?
That's a good question. There's typically a clause in a lease that says acceptance of amounts less than the rent due does not mean that the landlord has agreed to that's full payment. But again, just sending less than you owe is good, and the landlord's within their right not only to take that, but they don't waive their rights to try to collect the rest. But what I'm suggesting you do is to do a little more homework and to say, here's the reason why this is all I can pay you, and I'd like you to consider this payment in full for the time being. And you could start there, and you can say, or you could say, in the future, I'm expecting to see our business return to its normal state. I've been a good tenant, and so I'd like you to treat this as my deferred rent for this period, but I expect to be able to go back to full payment within 90 days or whatever your calculations show.
When it looks like we received a response to that previous question, it said somebody from the audience said the rent is usually about 6% of gross, should never be more than 10%.
Okay, that's great to know. I wouldn't.
Okay, and that's all the questions that I see.
Great.
So.
Well, good.
Well,
So if there's nothing else, thank you again. Let SCORE help you if we can.
Okay, great. Thank you, Bill.
You're welcome. Take care. Bye, Gloria.